be speaking with me, Tarun Nangia. Today, we are going to have a short discussion on the mediation bill or the draft mediation bill and inputs from an eminent panel that joins us today. They will share with us what all elements can be incorporated, if there are any amendments that can be done to it pre it being sent to Parliament. I have with me Sriram Panchu. He's a well-known mediator, senior counsel, author on books of mediation, and president of Mediator India. Also joining me is Nandini Gore, senior partner at Karanjawala and Company. She is a mediator, author, and distinguished fellow of the International Academy of Mediators and vice president of Mediators India. I have with me JP Singh. He is the founder, organizing secretary of Samadhan, which is the Delhi High Court's Mediation and Conciliation Center. So welcome all of you to this very important show. May I request at the outset to Mr. Sriram Panchu to make his opening comments on his expectations from the mediation bill.
You know, this is a new thing for India, to get an enactment for mediation. Mediation itself is pretty new in our country. It's only since 2005 that we started to introduce it in the courts. And it has now traveled a long way. You know, all along it's been something practiced only in the court annex mediation centers by lawyers doing it part-time. But the time has now come for it to be treated like a full-fledged profession, because it has grown to that extent. There are people who are engaging fully into mediation. And I think the value of mediation and benefits it brings to a wide range of users is now firmly established. And that's why we need to take mediation now to another level, a level where it can grow, where you have accreditation, you have institutes who train mediators, you have service providers who provide mediators to people, and different aspects of the practice and the profession. And I think it's in response to those needs that we've been thinking of a law for mediation. And a committee was set up by the Supreme Court of Senior Mediators about a year back, and all of us were on that committee. The committee produced, from its experience, a draft bill, which was then sent to government and went through various hands and has emerged. Now, a bill has come which I think is in part good and in part problematic. In part good because it firmly recognizes mediation as a profession. It talks about service providers. It says that if you have a mediation settlement, it will have the status of a decree of court, a judgment and decree of court. So very firmly enforceable, very difficult to challenge a mediation agreement, very few grounds. So all that is very good. It also provides for people to try mediation before going into litigation.
Yes.
So, that's an important step. We are one of the few countries, who's going to try that. And I think that will, that's very significant. Not that you have to succeed in mediation, but you must try it, a good faith attempt, at least one proper session with a mediator. So these are all good things. There are, in my mind, three problematic areas, and I'll just mention this and maybe we can talk about it later. One is that there is a mediation council, and it has a retired judge and one full-time member who's got some experience of ADR, another full-time member with experience of ADR teaching, and that's it. There are no mediators on this council. And we find this astonishing. Can you have a bar council, without lawyers? Will you have a medical council without doctors? Will you have chartered accountancy council without chartered accountants? So the absence of mediators on this, people actually were on the field who know what it's about, who know what to regulate and how to do it. Just a total absence of them. So this is like a government body. It's like a government body. It doesn't look like a body for a professional activity. So that is one thing which is of concern. And then the other is there is a very large list of exclusions, what you can't mediate. And again, I think that, probably like a cut and paste thing. Like you say, oh, there's an allegation of fraud who can't mediate. It's taken from the arbitration. All of that doesn't really hold good in mediation, because people make allegations and they plane, but finally they come, they talk, they settle it, they forget all those things. Similarly, grant for patents or telecom disputes. So all those exclusions, I think, are unnecessary. It's fine to say that, if something needs protection, supposing that there's a minor's interest. Now, don't say don't mediate it. You could have a case, for example, where there is one minor amongst 36 owners. And if you say don't mediate it, then you've lost that chance for everybody and that minor. The best thing is to say, well, if there is a minor's interest involved, make sure that a court says, yes, this is a good agreement for the benefit of the minor. And the third point, which is worrying, is that international mediation is a very important thing, because it allows people, companies in India and companies from abroad to engage in mediation. You now have the Singapore Convention. And the Singapore Convention does one thing, which because of that just beats litigation and arbitration. The convention says that you can enforce a mediated settlement anywhere in the world. So if I have a mediation settlement with, let's say, a company from England, I can enforce that settlement wherever that company has assets, whether it's in England, Australia, America, Europe, wherever. And a very simple way of enforcing. So, and the difficulties that come when we have to, enforce an arbitration award or a court decree. The Singapore Convention just, beats all that. So it's a brilliant enforcement. Now, what this bill does, and I think again by mistake, is that it clubs international mediation along with domestic mediation when it is conducted in India. And it says it has a status of a decree. But unfortunately, the Singapore Convention says if something is gone through your court and has a status of a decree, the Singapore Convention will not apply. So plain and simple, the result is this. If there is an international mediation, if you do it in India, you will not get the benefit of the Singapore Convention. You do it outside India, you'll get the benefit.
That's a good set of points shared with you in your introductory comment. I'll go to Advocate Nandini Gore at this point. Ma'am, any inputs that you would like to give on the mediation bill? Anything that you think has been missed out, or would you like to be amended or added? What do you think about the mediation bill?
Yeah. So Tarun, what I will do is what Mr. Pancho has touched, I will try to add something else to it. And this is really a welcome step, because after the Singapore Convention, we all had this way that something new is going to happen. And finally, this bill has come and it is now public comments are invited on it. So till now, we were piggy bang on the Arbitration Act and we were like given a stepmotherly treatment. But now it's actually a welcome step that pre-mediation litigation is made mandatory, which is the most important part. And I was going through the clauses. So, and also I was comparing it with the Singapore Mediation Convention. And I hope that slowly our bill drafter will also take care of this, that if a particular lawyer, the lawyers also have to be trained to see that every lawyer advises his clients that go for mediation. And in case they don't advise and the matter reaches to the court and the judges feel that there is something in this matter which should have been mitigated, there is a provision for penalty in Singapore Convention. So I am looking forward for that also. And another good thing in this bill is about online mediation, which is, the need of the hour. And they are going to give a lot of importance to online mediations. But the only gray area is, how to enforce the confidentiality part, how to get this agreement properly vetted, and how to tell a party that in a caucus section, when I am having a particular one-to-one talk with one party, how confidentiality has to be maintained. There are certain technical things which are to be added. And another thing which I would like to add is about community mediation. So there is a provision for community mediation also in this bill. But in that, the community mediation, they have made the SDM the in charge. Here again, I would emphasize that mediators from those local communities, people, who have some knowledge or who are a little bit of educated, they can be given a 40-hour training program and they can become mediators, because it is not mandatory requirement that you have to be a lawyer to become a mediator. So I think the regulation should not be there at any case. And what Mr. Panchu has added about the council and the members of the council, that they should be mediators, they should be trained. I would like to add another thing, that if you made a council in the center, it will be difficult for that council to regulate all over the country. So in different states, they should have a different body to take care of a particular state where accreditation can be taken care, education of the mediators like interactive programs, further training courses can also be added. So these are some of the points which are coming to my mind. Thank you.
Thank you so much for these inputs. I'll go to Mr. JP Singh. Your suggestions on the mediation bill. Of course, I know you would have earned a wealth of experience at the Delhi High Court running Samadhan. If you could share that also with us.
Thank you, Tarun. Tarun, two things I would like to say. This mediation bill is a welcome and necessary step. Welcome because there has to be a standardized training and training material for accreditation of mediators. It would prevent unhealthy practices and mushrooming growth of semi-skilled mediators. I call them semi-skilled. See, what circulation of this bill has done, it has brought mediation in public domain and into sharp focus. Today, discussions are happening on various platforms. We are doing that same here. It has increased public awareness and also amongst various stakeholders like public and private organizations, service providers, universities. I have queries coming from students who are looking at mediation as a career option. What we see in India today, after 89 CPC was amended in 2002, is mediation being practiced through court annex mediation centers. What this bill would do is also encourage private mediation. And mandatory mediation part, which Shriram Panchu talked about, you see, ordinarily there is a mindset in the mind of lawyers that if you recommend mediation, probably you have a weak case. So this mandatory mediation will do away with that. Idea being, as he said, try mediation. Not necessary that you have to settle your matter there. Then, it clears the air regarding enforcement of mediated settlements. Because earlier we used to have a problem on how to get when you have a pre-litigation mediation, how do you enforce that settlement? And we used to look up to the Arbitration and Conciliation Act as a stopgap arrangement because there was no law. Then what it's doing is it's removing the distinction between conciliation and mediation. We have from 1947 onwards, several statutes which talk of conciliation. Even 1996 Arbitration and Conciliation Act. Conciliation actually never took off the ground. But this distinction has been created, which this bill seeks to do away with. And of course, when I say necessary, because we are signatory to the Singapore Convention. And in order to ratify it, we need a domestic law. And therefore, I think this is a step in the right direction that the government is thinking of, or legislature is thinking of a standalone, legislation and mediation. So I think these are the areas, but of course there are areas of concern. Some of them have already been spelled out to you. Exclusion part is something, where I think it should be left. If you see there are about 16 types of disputes which have been excluded from the purview of mediation in Schedule 2. See, Supreme Court in Afcon's case, if you remember, clearly spelled out a broad category of cases in which mediation was helpful and in which mediation should not take place. There have been several judgments rendered by the Apex Court thereafter and various high courts. In general, expanding the areas and disputes where mediation would be an effective resolution mechanism. To my mind, legislature should take a cue from these judgments, and Schedule 2 of the bill needs a serious relook.
Okay.
And another area that which I feel leaving accreditation to service providers would again create a problem, on the standards of kind of mediators that will be ultimately assessed and would be doing. And one more area which I'm really concerned about is Legal Services Authorities Act. See, Legal Services Authorities Act was created for purpose of providing legal aid. Even under the Commercial Courts Act, Section 12A, how the process of mediation has to be enforced is again through the Legal Services Authorities Act. They don't have the wherewithal, nor the infrastructure, nor a panel of mediators. Ultimately, they are depending on court-annexed mediation centers. And here also, again, there is a distinction created between the mediation under the Mediation Council and under the Legal Services Authorities Act. All these areas, I think Legal Services Authorities Act was not meant for this purpose. And too much of emphasis is being given to, or the role is being given to the Legal Services Authorities Act. I think these are the areas which I would talk about here, and maybe later on we can go into.
Thank you for sharing this. Mr. Panchu, what are the gray areas that you would like to highlight in the draft mediation bill?
I think principally the ones we spoke about, the composition of the council, what JP said, the role of the Legal Services Authorities Act, the exclusions, the excessive, I think, exclusions, and international mediation, making sure that we haven't, created a problem for ourselves. I mean, we want India to grow as a hub for mediation. We want it to be a robust hub. And we say it's important for the ease of doing business. So we shouldn't shoot ourselves in the foot by, drafting it in a way it makes it, takes away conducting international mediations in India. So I think these are the three or four things. And I don't think, it takes long to get it right. These are just, 4 or 5 basic, they're important, but they don't take, I don't think we need more than a sitting or two just to kind of tweak it and get it right. And then we're okay. We have something which works. I just hope that consultation and that sitting across the table with experienced mediators takes place now. Yes. Because, that's important.
Okay, thanks so much. Now, since we are almost out of time, but I'll quickly take 2 more comments. One from Ma'am Nandini Gore and then from Mr. J. Any gray areas that you would like to highlight, Ma'am Nandini Gore?
Yeah, so I am not going to, repeat what Mr. Panchu has said, but 2-3 things which are coming to my mind very quickly is this, that he said that the Schedule 2 should go according to me, because they have made a long list of matters which cannot be decided by, in this particular mediation bill by the mediation. So they are going to exclude it. What I feel is when you are starting online mediation also, matters like matrimonial dispute, commercial dispute, IPR, patent, why can't you take patent and IPR also in this particular thing? Even the tax matters also, what is wrong in taking tax matter also under the purview of mediation? Yes. And when you are doing online mediations, there are different type of, traffic challans are there, petty offenses are there. You can exclude that and keep into the category of online mediation, and those can be resolved. So why should you keep some things which are already there under the CPC, which are totally excluded? So my point and my take is this, that we should add everything under the sky only some very, very grave offenses, leave them apart. But first trial should be there for mediation for all these things. So this is what...
You made a couple of very important points. In fact, the issues of traffic challans are applicable to almost all the population in the country.
Correct.
Tax is another issue which is applicable to a large section of the population. So we could, in a sense, discuss that further also in some other episode. Mr. JP Singh, a closing comment on today's show from you.
Arun, on the same lines, Section 138 Negotiable Instruments Act, the courts are clogged today. In a reference made to the Delhi High Court, the division bench calls it a quasi-civil matters, but they are criminal matters. So how to deal with criminal matters when a settlement happens? I think the bill should also look at how criminal matters can also, when the settlements happen, how can they be enforced? And one gray area, if you see, is a confidentiality issue. In the bill, they have said audio-video recordings can also happen, which is totally against the tenet of confidentiality. So these are certain areas which I think need a relook, but I think there should be healthy criticism. We need a bill. There should be healthy criticism of the bill, yes, so that the parliament can have a relook at it and bring about a wholesome, good bill. Okay. That's what my whole take would be on.
Thank you. More than I could have asked for a very good set of points on today's show. I hope the government and the concerned bureaucrats take this into account. And if at all you go for a meeting and speak there, if the inputs can be discussed, we'll have a very healthy environment in this bill is finally passed into law. And as a lot of judges have also said, we all need a very healthy mediation ecosystem in this country. The pendency is very high. Mediation is all there for helping people. We hope we see good light at the end of the day. I would like to thank Mr. Sriram Panchun, Ma'am Nandini Gore, Mr. JP Singh for sparing time for this show. Thank you, viewers, for joining in. Thank you so much.
Thank you.
Thank you.
Thank you for calling us.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.